Okay, class, these are going to be your tests. And so you have your 140 number 1 jury charge. You have Jose Lawrence Luca, Little Rock, Fort Smith, TV. And this is jury charge test number 1 for 5 minutes. Good afternoon, ladies and gentlemen of the jury. I'd like to admonish you once again that if you can't hear something I'm saying to you during my final instructions, raise your hands right away and I'll speak louder. However, I think I'll probably speak loud enough initially for everybody to hear me. I generally don't have problems with that sort of thing. As far as those of you in the audience are concerned, no one will be permitted to enter or exit while I am instructing the jury. We can avoid that problem if any of you who believe you might need to leave will leave now before I start my instructions. Ladies and gentlemen, the defendant here is Jose Lawrence Luca. He is charged with 2 separate informations charging him with the crimes of robbery and burglary. These 2 informations are separate and distinct and are not to be confused as being the same one. The defendant has pled not guilty to both of the informations brought by the attorney of the city of Little Rock. I am sure you are all well aware of the fact that you have chosen and have been chosen through voir dire, sworn under oath, and accepted as members of the jury, which will determine the guilt or innocence of this defendant of the charge contained in the 2 informations. You will recall that the oath you took as jurors states that you will fairly and truly try charges made by the city of Fort Smith against the defendant and render a verdict that is in strict accordance with your review of the evidence. You are not to let any false or incorrect views that you may have gained from outside of this courtroom to interfere with your own judgment in your deliberations here in this case. The guilt or innocence of this defendant is to be decided by you only on the basis of the evidence introduced during this trial and decided on that basis and that basis alone. You must not be swayed by any pity for the defendant. We are all here in this courtroom for one reason, and that is to find the truth. After having discovered the truth, we are here to administer justice according to the law of the land. After your deliberations, you should find the facts based only upon the evidence. You should judge the case on the evidence and on the evidence exclusively. After you listen to all the facts in this proceeding, you must apply to those facts the law as I shall deliver it to you or give it to you in these instructions or this charge. After you have done all these things, then you will decide your verdict in this case in accordance with the evidence and the law. It is the responsibility of a judge to deliver instructions in a tone of voice that is not indicative of any leaning toward one side or the other. For that reason, please disregard anything in my voice that you might interpret as a bias for either side on my part. I have none, and you should not attempt to conjure up a bias from the tone or tenor of my delivery. I will adjourn court for the day after my instructions as the hour has become late. When you go home tonight, be careful not to read any newspapers or watch any TV shows that might carry coverage of this trial. I have not any TV crews here, but that does not necessarily mean they haven't been somewhere outside. Usually their coverage is far removed from what actually happened in this courtroom, and I don't want any of you to become tainted as jurors by listening to what is said or written. Thank you, folks. Court will be adjourned until tomorrow morning at 9 o'clock sharp. If you'll make it a point to get back in on time, you'll find some biscuits and coffee waiting for you here. It's important that you get here with time to spare because I don't want to be sitting around here waiting for one of you as we were. If you can't make it on time, and then you have on your 140 number 2 test, the court capit, and you write it DORT, D-O-U-R-T. Okay, this will be 140 number 2 for 5 minutes, jury charge test. Ladies and gentlemen of the jury panel, the use of force or violence on the person of another is justifiable when it's for the purpose of stopping a forcible act against the person or a forcible act or trespass against property in a person's lawful control, and that the force or violence used has been reasonable and also needed to stop such offense. A homicide is unjustifiable if, when done in its self-defense by one who reasonably feels that he is in imminent danger of losing his life or receiving great bodily harm, and that the killing is needed to save him from that danger. 2, when done for the purpose of stopping a violent or forcible felony involving danger to life or of great bodily harm by one who reasonably thinks that such an offense is about to be done and that such action is necessary for its prevention. The circumstances must be such to excite the fear of a reasonable person that there would be a danger to his own life or person if he tried to stop the act without the killing. A homicide is also justified when done against a person whom one reasonably feels to be likely to use any unlawful force against a person there in a home or a place of business while committing or trying to commit a burglary of such home or business. The homicide shall be justifiable even though the person does not retreat from the encounter. In order to justify a homicide as being in self-defense, the one who is attacked must really feel that he is in imminent or immediate danger of losing his life or of having serious personal harm. Such a belief must also be a real one. The danger need not be real, but the one confronted, threatened, or attacked must really believe that he is in actual danger. Not only must the person really believe he is in imminent or certain danger, but he must also really believe that it is needed to kill in order to save himself. Now, a person who is the aggressor or who brings on a difficulty cannot claim the right of self-defense unless he withdraws from the conflict in good faith and in such a manner that his adversary knows or should know that he wants to withdraw and stop the conflict. This rule of law means that a person who initiates or starts a confrontation wherein he assaults, threatens, attacks, or harms another one cannot claim self-defense if the person he first confronted fights back, unless that person who started the conflict withdraws from the conflict in good faith and in such a way that the person he first confronted knew or should have known that he wanted to stop and end the conflict. Now, ladies and gentlemen, when the state seeks to introduce any statement allegedly made by a defendant while in police custody, the state must first lay the proper foundation to show that the alleged statement was freely and voluntarily made by the defendant, and that the defendant had been advised of his right to remain silent and his right to a lawyer prior to the alleged statement being made. If the court says that any alleged statement was obtained in a legal fashion, the alleged statement will be allowed into evidence. After the alleged statement is admitted, it is up to the jury to decide what, if any, weight you wish to give the alleged statement. In other words, you may find it to be true in part and false in part, or completely true or completely false. In deciding what, if any, weight you wish to give to the alleged statement, you are to attach no significance whatsoever to the fact that the court has allowed the alleged statement to be introduced. In considering what, if any, weight you wish to give to the alleged statement, you should consider the contents of the alleged statement the same as you do all the other evidence in the case. You should also consider the circumstances under which the alleged statement was made. A statement need not be the spontaneous act of a person. And we'll get ready for your 120s, okay? And so on your 120 jury charge number 1, you have George Borgia, Mr. Borgia, Internet. And this is going to be 120 number 1 for 5 minutes. All right, ladies and gentlemen, I'll now ask you to retire to the jury room to begin your deliberations. You'll be provided a copy of the jury instructions, and the exhibits introduced as evidence will be made available to you. Prior to beginning your deliberations, you will need to select one of you to act as foreperson. That person will preside over your deliberations and will speak for the jury here in court. Forms of verdict have been prepared for your use. You will take these forms with you to the jury room. When you have reached unanimous agreement as to your verdict, the foreperson will sign the forms which express your verdict. You will then return all forms of verdict, these instructions, and any exhibits to the courtroom. Who is George Borgia? Mr. Borgia, you were our alternate in this case, and if you'll remain in the courtroom, I'll have some additional remarks for you. All rise, please. Follow the bailiff. You may be seated. Mr. Borgia, you may have kind of noticed this. Over the course of the last couple of days, you realized there were 13 of you rather than 12, and naturally juries are made up of 12 people, but we select an alternate for virtually every trial, at least one, as kind of an insurance policy, because if over the course of the last 2 days somebody fell ill or had a family emergency or something and couldn't complete the trial, we need to have 12 people who've heard all the same evidence, heard the same arguments, and seen the same evidence. And the only way we can do that is to have an alternate. And then if somebody does drop out, we have somebody who's been there right shoulder to shoulder with the other jurors. So just like with car insurance, it doesn't happen every day that you have a wreck and have to make a claim, and it doesn't happen every day that we have to employ the alternate in the deliberations, but it happens often enough that it's important to us that we do it. So I know that alternates are sometimes disappointed. Here I've told you what you can talk about, what you can't talk about, what you can watch, what you can look up on the internet, what you can't, and I have every reason to believe you've honored that, and yet you don't get to participate in the final act of the trial. And if You share that frustration that some people have. I understand, but please be assured that your service here has been important to us. For 2 days, I've been telling you you can't talk about the case, and the alternates wonder now that my involvement with the case is over, what's my responsibility? The answer is you're free to talk about this case with whomever you'd like. You're equally free not to talk about the case if that's your choice. It's not uncommon for the attorneys and their staffs to want to talk to the alternate. And if you're willing to do that, there's absolutely nothing wrong with doing that. But if you don't want to do that, there's nothing wrong with declining to do that. If today or at any time in the future, anybody tries to compel you to talk about the case and you've decided you did not want to talk about it, please report that to the court and we can take action against that party. All right? But at this time, without any further delay, you are excused. And then you have your 120 number 2. You have proper names. State, capitalize it when you can replace prosecution. The state. Count 1, Cesar Montes, New Mexico. Count 2, William Richards. And this is going to be 120 jury charge number 2 for 5 minutes. All right, ladies and gentlemen, you have heard all of the evidence. It is now my duty to tell you the law that you must follow in this case. The law governing this case is contained in the instructions that I'm about to give you. It is your duty to follow the law as contained in these instructions. You must consider these instructions as a whole. You must not pick out one instruction or parts of an instruction and disregard the others. A copy of these instructions will be given to you when you begin your deliberations. The law presumes the defendant to be innocent unless and until you are satisfied beyond a reasonable doubt of his guilt. The burden is always on the state to prove guilt beyond a reasonable doubt. It is not required that the state prove guilt beyond all possible doubt. The test is one of reasonable doubt. A reasonable doubt is a doubt based upon reason and common sense, the kind of doubt that would make a reasonable person hesitate to act in the graver and more important affairs of life. You are the sole judges of the facts in this case. It is your duty to determine the facts from the evidence produced here in court. Your verdict should not be based on speculation, guess, or conjecture. Neither sympathy nor prejudice should influence your verdict. You are to apply the law as stated in these instructions to the facts as you find them, and in this way decide the case. You alone are the judges of the credibility of the witnesses and the weight to be given to the testimony of each of them. In determining the credit to be given any witness, you should take into account, among other things, the witness's truthfulness or untruthfulness, ability and opportunity to observe, memory, manner while testifying, any interest, bias, or prejudice the witness may have, and the reasonableness of the witness's testimony considered in light of all of the evidence in the case. Each crime charged in the indictment should be considered separately for you to find the defendant guilty of aggravated battery with a deadly weapon as charged in count 1, the state must prove to your satisfaction beyond a reasonable doubt each of the following elements of the crime. 1. The defendant touched or applied force to Cesar Montes by stabbing and or cutting Cesar Montes with a knife. 2. The defendant intended to injure Cesar Montes or another. 3. The defendant did not act in self-defense. 4. This happened in New Mexico on or about the 22nd day of June 2013. For you to find the defendant guilty of aggravated battery with a deadly weapon as charged in count 2, the state must prove to your satisfaction beyond a reasonable doubt each of the following elements of the crime. 1. The defendant touched or applied force to William Richards by stabbing and or cutting William Richards with a knife. 2. The defendant intended to injure William Richards or another. 3. The defendant did not act in self-defense. 4. This happened in New Mexico on or about the 22nd day of June 2013. Evidence has been presented that the defendant acted in self-defense. The defendant acted in self-defense if 1. There was an appearance of immediate danger of death or great bodily harm to the defendant as a result of the threats of great bodily harm or death made by Cesar Montes to the defendant, and 2. The defendant was in fact put Okay, so that concludes your test, you all. Have a great day. Type 1 up, see how you're doing. We're at the halfway point, so make sure that you all do that now, okay? Have a great day.